many people, Lionel Murphy was the best Attorney General Australia has ever seen and our most influential High Court judge. By the time of his death, he was the most senior legal figure in the modern history of the Commonwealth to be dragged through the courts on a criminal charge. Well, he's not there as usual. It's typical. Mongrel. Well, we'll start with Collins. At least we know where he is.
What do you blokes want?
You know who I am, Mr. Collins.
Yeah, I've seen you around the store, yeah.
Know my position. I'm chairman of the council. I was elected to speak for the people.
I wouldn't know about that.
Well, we just come from the office and there's no one there, so we come to see you. We can run our own affairs. We want you to tell the department that, okay? Because we're sick and tired.
You go and see the chief officer. That's his responsibility, not mine. I'm in that position.
You run the store, don't you? You work for the department, don't you? You're white? Well, we want you off our reserve. The whole lot of us. We keep telling you all, but no one seems to be listening. We can run the ride by ourselves.
Your action in taking unto yourself the task of removing all whites from Yarrabah cannot be condoned from any angle in which you may view community affairs. Violence is something in recent times which has crept into Aboriginal communities. I blame your type for this growing hatred of black against white.
Mr. Neal was sentenced to 2 months hard labour for assault by spitting at Mr. Collins. On appeal to the Queensland Supreme Court, the sentence was increased to 6 months with hard labour. Mr. Neal then appealed successfully to the High Court of Australia. Lionel Murphy was a justice of that court. That Mr. Neal was an agitator or stirrer in the magistrate's view obviously contributed to the severe penalty. If he is an agitator, he is in good company. Many of the great religious and political figures of history have been agitators, and human progress owes much to the efforts of these. As Oscar Wilde aptly points out, without them in our incomplete state, there would be no advance toward civilization. Mr. Neal is entitled to be an agitator. What Murphy said for this black man in Queensland could also have been said for Murphy himself. The Lionel Murphy story might then have been quite different.
We met in Sydney in about 1961 through a friend of mine. Lionel was practicing at the bar at the time, and this friend needed some legal advice, so I came along, and that's virtually how we met. Didn't see one another for a long time, and then re-met after a few years.
Murphy and I go back to the days when we were actually undergraduates at university together. Lionel was a science student. I was a sort of an arts-type law student, but really just having a good time at that time. And Murphy was always a person with serious views about serious issues, even then.
I'm not sure that he ever fitted into conventional party politics or to any other conventions. There was something really iconoclastic about him, and people either found this really refreshing and exciting or disturbing in some gut way, so that people either loved him or hated him.
He was a very persuasive person, very insinuating and cajoling in tete-a-tete situations. He would have a word which would be very convincing with individual senators.
In 1972, Lionel Murphy was appointed Attorney General, and he quickly came into conflict with the Australian Security Intelligence Organisation, ASIO.
When he got into Parliament, Labor was then in opposition, and by the time he got into government, it had been in opposition for 23 years, and there are all sorts of perceived injustices to be corrected, and he was at the very forefront of the forces that sought to correct them. Not the least was our perception that ASIO was an insidious force in Australia, and something needed to be done.
I think all of them felt, as a lot of the public does, that there have been abuses of the organisation. Half felt that it should be done away with because of that. The other half thought that the abuses should be brought under control.
What sort of abuses?
Abuse, they're going outside their charter, the ASIO being used for political purposes rather than for the security of the country.
One thing that certainly attracted a lot of headlines and haunted him forever after was the so-called raid on ASIO. He always insisted that that wasn't a raid. He called it a ministerial visit. He was the minister responsible for ASIO. He believed that they were not supplying the government with files that they needed to deal with Croatian terrorists. So early one morning, he and a party of helpers descended on the ASIO office in Melbourne and helped themselves to the files.
Well, the ASIO raid was just amazing because it had two extraordinary features about it. The first was that he did it. I mean, usually attorneys general stand back and they sign a form or hope that someone else will sign it. But no, there he was. Not only did he authorise it, but he supervised it. I think that owes a lot to his convictions about the sort of American way of approaching matters of civil liberties and protections, because this definitely was almost the sort of sheriff going in on the job.
I remember the controversy about that in Parliament and the way he defended what he'd done in Parliament. Again, some of us found the defence entirely convincing, and others thought that apart from the rights and wrongs of the issue, this dawn raid on ASIO was just a totally unacceptable way for a minister to act.
For several years, dating as far back as 1963, there'd been a series across several states of bombings. There had been some deaths resulting from these attacks, and the previous government, the Liberal Country Party government, had consistently denied that Australia was facing any threat from organised Croatian terrorism. The Yugoslav Prime Minister, Mr. Bijetic, was due to visit Australia, and a report from the Commonwealth Police came through to Murphy which indicated that the extent of threat, the level of threat that existed against Mr. Bijetic was far greater than Murphy had previously been led to believe by his discussions with ASIO officials. With that in mind, he went to ASIO and asked to see any information they had on Croatian extremism in Australia, and he found indeed that ASIO had been withholding information from him.
Most Labor people despised ASIO. They regarded it as a sort of an amateurish cops and robbers thing, and they're peopled by extravagantly Reds under the bed people, as it was, of course. ASIO has always been a great waste of time, I thought. But Lionel got the idea, probably correctly, that ASIO was either bugging him or was treating him as an opponent and was, had some sort of surveillance out on him. And he was probably right.
There was certainly, following Murphy's visit to ASIO, within the security services around the world, a great deal of consternation. That was not the first episode which had placed the CIA or MI5 in a position of concern as to the operations of the Whitlam government. One of the first things that Whitlam did upon achieving office was to say that his private staff would not be subject to security clearances. Now, of course, that created an absolute furore.
Some of the major secrets that deal with the world I was once in were given to the Australian security services. And when we saw this Whitlam government come into power, and this Attorney General moving in, barging in, you don't see the jewels of counterintelligence being placed in jeopardy by a party that had extensive historical contacts in Eastern Europe, that was seeking a new way for Australia, seeking a matter of compromise, seeking roads to Peking.
Well, I think this was possibly the first such episode to demonstrate to the Australian public that secret police forces had their own agenda, that they set themselves above governments and above the community, that they made their own judgments as to what was right and safe for the community, regardless of the community's opinion, and that they sought to conceal their own processes without accounting to anyone, that they gave information to other governments but not our own. Murphy, of course, was entirely correct in demanding accountability from ASIO, and perfectly correct in taking personal action to see that he got it.
Murphy developed a profile which disturbed certain elements of what I call the establishment. And don't ask me to define who are the establishment, I don't know. But there were forces working in the community against Murphy and to get Murphy, and ultimately they succeeded.
Prior to his visit to the Melbourne headquarters of ASIO, Lionel Murphy had been in Parliament for more than 10 years, 5 of them as leader of the Labor Party in the Senate. But what did the public know about the new Attorney General? What was the background of a person who could behave in this way? The bulletin promised to give us the detail. The story claims that Murphy is an enigma, his origins obscure, that he could be of Jewish origin, but that he refused to either deny that or alternatively own up and wear his origins.
I'm not talking about an investigative journalist, but if they'd simply taken a common sense attitude and at least looked up who's who, they would have found a lot of information that was about his background that was supposed to be mysterious. It's mysterious as the nose on my face.
It might have spoiled the enigma, but any edition of Who's Who in Australia from as far back as 1962 would have indicated that Lionel was indeed the son of an Irishman named Murphy, and as chance would have it, his mother had also been born with the name Murphy.
He did everything with gusto in his life. He lived it with gusto. He just spent all his time enjoying things. He was one of the rare people that I've ever met who enjoyed every day of his life. It was quite unusual, and enjoyed doing the things that he did, whether it was eating, whether it was making legislation or speaking, anything.
He was a man of enormous vitality. When Lionel came into a room, it was like an electric current. You felt more alive when Lionel was around. He was an immensely attractive man.
Lionel Murphy was born in Sydney on August 30, 1922. He lived in the Sydney suburb of Kensington, and he attended Kensington Public School, where he was dux in 1934. Murphy's education continued at Sydney Boys High, and he was a prefect in his final year. By 1949, he had graduated as an honours student in science and with first-class honours in law. He was admitted to the bar in New South Wales at the same time as Gough Whitlam, and he set up as a barrister in the same chambers as Neville Wran.
Well, he had a phenomenal road to the law, if I might say so. He knocked over the entrance exams to the bar, which most people take a few years to do. He knocked those over in 14 or 15 months, finished up with honours degrees in science and probably law. And he was a person with an extraordinarily high IQ who immediately he became a barrister, devoted himself, not entirely, but to a large extent, to public interest issues. It wasn't long before he was at the forefront of the bar that concentrated on industrial issues.
It was during these early years at the bar that Murphy first met a Sydney solicitor named Morgan Ryan.
A lot was made of his relationship with Ryan. I think that showed Murphy at his most reckless. There was never anything sinister in it, but he carried his loyalty to Ryan too far, I think.
Ryan had a blossoming practice in industrial law, and he often briefed Murphy. In one of the more celebrated cases, Murphy and Ryan secured a win over John Kerr QC and Jim McClellan that saw the right-wing leadership of the Federated Miscellaneous Workers Union ousted, and Ray Geetzelt installed as Federal Secretary. Geetzelt was to become a major power broker in the New South Wales Labor Party. Murphy stood for Labor Party pre-selection for the Senate election of December 1961. Characteristically, his pre-selection speech was on the topic of civil liberties, and on July the 1st, 1962, he entered the Senate.
Perhaps I've got an emphasis on matters of democracy and ensuring personal freedom. I think the party needs to concentrate far more on these matters than it's done in the past. In the past, we've tended to concentrate on uplifting ourselves materially. That's the whole of the community in the material way, and I think in the future that we ought to concentrate much more on the questions of personal freedom, democratic procedures and dignity of the individual.
Well, the right wing of the Labor Party of those days was a very dogmatic, intolerant, red-baiting sort of an outfit. And because Lionel appeared for people who were considered to be way over on the left, and even for some communists, that didn't bother him, he got tarred with that brush. He was always, therefore, regarded by the right with great suspicion. He didn't hate them. I don't think Lionel hated anybody, but they certainly hated him.
He just wanted to bring us up to date into the 20th century. He thought we were living in the 19th century, and he wanted to do something about it. And that's one of the reasons why he went into politics.
There were so many inequities, inequalities, unfairnesses within the community, so many things that needed to be righted. The position of Aborigines, the position of women, position of minority groups, the lack of anti-discrimination legislation as far as minority groups were concerned. All of those things needed to be done, and we saw a great opportunity.
Yes, it's time. It's time for freedom. It's time for movement. It's time to begin. Yes, it's time. It's time for all folks. It's time we love them. It's time to care.
In December 1972, the Australian Labor Party came to power after 23 years of Conservative rule. Gough Whitlam was Prime Minister, and Lionel Murphy was to be appointed Attorney General.
The effectiveness of Murphy as a legislator was shown particularly in respect to the Family Law Bill. Now, this was not a party matter. In the Senate and later in the House of Representatives, it was regarded as a conscience matter. That meant that senators and representatives could vote as they saw fit. And the whole subject matter of the Family Law Bill was controversial. There were strong views expressed in the community against the bill. But Murphy persuaded his colleagues in the Senate to pass the bill by 49 votes to 7. So there is no question that he was an effective legislator.
With the environmental issue, Lionel Murphy did have a very great deal of foresight. He was concerned about nuclear testing in the Pacific, and in fact, as Attorney General, took the matter to the International Court of Justice.
Well, I think we can appeal to the French. We've been friendly with the French for a very long time. We regarded them as a civilized nation, and they ought not to do in the Pacific what they were prevented from doing in North Africa, and that is to infringe our sovereignty by testing and having radioactive fallout over our own people, our own land, our environment, and against our will.
Will other countries support you?
There's a great deal of support already right across the Pacific. You might have seen New Zealand is very angry about it, and other nations also are very angry about what's being done.
Well, at the same time as Australia was concerned, and Murphy was concerned about French testing, the New Zealand Prime Minister, Norman Kirk, decided to become the biggest protester of all. And New Zealand sent a couple of frigates there to protest the French nuclear testing. And the companion measure was to join with Lionel Murphy, and Dr. Martin Finlay, the then New Zealand Attorney General, went with him, and together they argued for a cessation of French nuclear testing. The French eventually gave an undertaking that they'd stop atmospheric testing. And in terms of New Zealand, Australian political and legal relationships, that marked a very high point indeed.
But the enduring significance is this: it was the first case to come before the International Court of Justice concerning the environment. And what the international community will increasingly be doing now through the United Nations is to make conventions dealing with the environment. And we blazed the trail for seeing that international laws could be made on that subject, and they could be applied by the International Court of Justice.
The people that knew him and had met him, most of them held him in terribly high respect and regard. Where he wasn't so much liked were the people who'd never met him. And they were virtually forming opinions through newspapers and some of the reforms that he was making. Obviously, a lot of the reforms weren't very popular with a minority of the population.
Now, Your Honour may recall an incident some 2 years ago when the child of the petitioner and the stepson of the respondent was kidnapped. It is the behaviour of the respondent...
I'm Mike Dorsey. This is Divorce Court. Whether in our own families, amongst our friends, or by our own doing, every single one of us will be touched by divorce. If you haven't been, you will be. This is fact.
Formerly, people could hate each other's guts, been living together and hating each other for years, and you had to prove what was known as a matrimonial offence, habitual drunkenness, desertion, adultery. Well, Lionel's view was, what's that got to do with a marriage? If it's not working, it's not working, and it should be as painlessly terminated as can be imagined.
This is a worldwide trend, and it's the public demand in Australia, and it's been for some time, and there's no possibility of it remaining as it was. The There is going to be cheaper divorce, it's going to be more dignified, and it'll be simpler, and this will be entirely in the public interest.
So when the Family Law Act came in, it got rid of that scurrilous notion in the law that there should be evidence of guilt, there should be evidence of fault in order for two human beings to gain a divorce, and it brought in the proposition that there ought to be one ground of divorce only, and that would be breakdown of marriage, and as long as the marriage had broken down for 12 months, then that was all that one had to show.
There were so many things that he did and that he started. The moves towards administrative law reform, the Trade Practices Act. When one thinks of it, it's really a most dazzling set of achievements that in so short a time he should be able to do so much, because it's the whole lesson of our system of government that ministers, elected governments, can generally only move as fast as the inertia of the public service.
On February the 9th, 1975, Murphy tendered his resignation as Attorney General to the Prime Minister, Gough Whitlam, and agreed to take up the position of High Court Judge.
The vacancy had unexpectedly occurred. I was there and he was there on the evening where Justice Menzies died in the midst of a Bar Association function. And that opportunity was presented unexpectedly to a Labor government. The question of finding somebody who would have values that they would hope would reflect the general sentiments of a reformist government was not so easy in the legal profession.
The Conservative lawyers were horrified. They cried, of course, jobs for the boys. Each side of politics objects to jobs for the boys. That when they do that, they mean jobs for their boys. Nobody objects to jobs for our boys.
Oh, there was a lot of humbug about appointing a politician, but of course nobody could effectively advance that argument because a frustrated politician, one who had not been a successful legislator, Barwick, he was appointed to the High Court. So quite obviously there was a former Liberal Attorney General as Chief Justice, and nobody could say that therefore it was improper to have an immediate past Labor Attorney General sitting on the same court.
Well, it's quite clear from the developments that are occurring elsewhere in similar systems that there'll be a great upgrowth in the environmental laws and consumer protection laws and the general access of the people to the courts and the field of human rights and administrative law. The changes that are happening in society are being reflected in the courts elsewhere and here. This has always happened over the centuries, and it's clearly going to happen over the next few years.
Murphy had been on the High Court bench for only a few months when a private prosecution was brought against him. It was 1975, and the charge was part of a political furor that became known as the Loans Affair. At its centre were four of the most prominent ministers of the Whitlam period: Whitlam himself, Jim Cairns, Rex Connor and Lionel Murphy. On the periphery, a little-known Sydney solicitor, Danny Sankey. Sankey had alleged that the four ministers had conspired to deceive the Governor-General, Sir John Kerr, into authorising a major government loan.
The Sankey and Whitlam prosecution throughout never did become anything more than a private prosecution by one man, Danny Sankey, but certainly everybody in the Labor Party believed that the Liberal Party was behind it. The real target was Murphy, because if they'd been able to convict him on either of those charges, then they would have had evidence of misbehaviour that they could use to remove him from the High Court bench.
It was transparently politically motivated, and I never took it very seriously. And Lionel didn't talk to me much about it, but I suspect, in retrospect, that it had him pretty worried.
It was at this time that New South Wales police were conducting an illegal telephone tapping operation using telecom logos and paraphernalia without Telecom's authorisation. Lionel Murphy was to fall victim to this secret surveillance.
I can think of one person coming up to me at a trade union function who said that when they first heard Lionel Murphy speaking in the Senate as a senator, they thought, that's one of us. It's the first time that we've really heard one of us speaking out in that way. And that was the message that came through from his judgments on the High Court too, that it was a person who had a real concern about the disadvantaged, about the dispossessed, and who believed, astoundingly, that the legal system was not there just to serve the ends of the powerful, of those who were the moneyed, those who were rich, those who were in the upper echelons or thought that they were.
Remember when Lindy Chamberlain was convicted? There was a move before the High Court to quash the conviction. And the High Court, a majority of the justices, refused to do so. But two of them would have quashed the conviction, and Murphy was one of them.
He skipped the highfalutin verbiage with which lawyers like to mystify the simplest matters, and got straight down to the point, and his language is punchy without any elaboration.
And just as a great British judge, Denning, used to write judgments that people marvelled at their style, so the Murphy style, you know, is really quite unusual. He actually tells it how it is, and he portrays in his judgments the background to it. He doesn't care about venturing off into controversy. If someone had spat at someone in an Aboriginal reservation, you get the whole history of reservations and the catering arrangements and the grocery shop and the background to it. And thereafter there comes the conclusion, which is a very, very incisive commentary on the state of race relations in Queensland at the time.
One morning during the course of writing the judgment in the Neal case, Lionel Murphy came striding into chambers, and I could have said rushing, although he never ever did rush, but what came with him was a rush of expectation, a wind almost of expectation, and said, I've just been reading Oscar Wilde's The Soul of Man Under Socialism, and there's a quotation in there that we must put into the judgment about the right to be an agitator and so forth. But including in the judgment the reference to the soul of man under socialism is a perfect example of the way that he understood and recognised that the law isn't something static, that the law isn't something that one finds only in law books, that one can find relevant sources from other areas.
He could probably see better than most the opportunities for creativity and achievement in the court. And I think the combination of these factors were probably the explanation of why he took the post. But he took it, and he became a most interesting member of that court, quite unlike anybody before or since.
By early 1984, Murphy had been a Justice of the High Court of Australia for 9 years, and for most of that time without controversy. A rare leading article in the Bulletin on the 20th of March 1984 suggests that Murphy is having considerable influence on the bench and on the other judges of the court. It seemed inevitable that the government would appoint Murphy to the most senior position, that of Chief Justice of the High Court. But the Labor Party in government is far more easily open to attack for arranging jobs for the boys than are the Conservatives. 1 week later, the government is under attack. Stories printed in the Melbourne Age, which were quickly dubbed the Age Tapes, contained references to illegally bugged conversations between Murphy and longtime friend Morgan Ryan. Ryan was alleged to have contact with organised crime figures. Murphy was alleged to have spoken to Ryan. Calls from the press and the opposition mounted for Murphy to be removed from the High Court bench. On the 28th of March 1984, a Senate hostile to the Labor government established the Senate Select Committee on the Conduct of a Judge.
During the Murphy affair, most of the allegations against Murphy had something to do with his supposed friendship with the Sydney solicitor Morgan Ryan. Murphy always said, yes, back in the 60s when I was at the bar, Morgan Ryan used to brief me a lot, and we were quite good friends. But he said, I've hardly seen him since. Morgan Ryan was the solicitor for Jim Cairns. In the course of that case, the acquaintance between Murphy and Ryan was renewed. Certainly the one tape that survived was all about Sankey and Whitlam, and what was being discussed was a proposal which Murphy was chewing over with Ryan, that the defendants, having won the case, should now turn around and sue for malicious prosecution.
The making of the Age Tapes was part of one of the biggest organised crimes in Australia's history, because what in fact happened was that a number of members of the New South Wales Police Force took it upon themselves to tap indiscriminately and unlawfully people's telephones. And one of those targets that was selected was obviously Lionel Murphy.
What's your reaction, sir, to knowing that police officers have and possibly still are bugging telephones then?
Well, it's the reaction of anyone. That means that they're breaking the law and it will not be permitted, and they've been told publicly, and I think even the previous administration gave some indication, but now they've been firmly told that there is no authority whatever for them to tap phones, and no permission can be given by anyone, however highly placed in the states.
We had a long discussion once early in the days of the government about telephone tapping by the Americans. And he said, look, if they're going to tap my telephone, they're going to have to do a lot of work to pick up the conversation. And if they do pick up the conversation, bugger them. Let them pick it up. I'm not afraid of anything I say in this house.
The group of police who were involved at that stage in the BCI and were carrying out this massive illegal taping operation met on a number of occasions, once at the Western Suburbs Soccer Club, another time in the Remington building. There they were addressed by Superintendent Shepherd, who was head of the BCI at that time. He said, according to the testimony of one of the officers, something along these lines: we have not been engaged in this 15-year taping operation. There's no products of this operation. None of us here have been involved in it, and indeed we're not even here at this meeting. This meeting didn't take place.
the illegal equipment, which had been bought illegally, assembled illegally, put into premises illegally, and used illegally over a number of years by members of the New South Wales Police Force. It was all loaded into a police boat and dumped off Sydney Heads. But just by a coincidence, some tapes that could hurt Lionel Murphy and reflect upon the Labor Party were saved.
The Age tapes, as delivered to the Age by Bob Bottom, comprised some 500 pages of transcript and summaries and a very small number of tapes. And certainly in relation to any conversation with Lionel Murphy, there was one tape. Both the Commission and one of the Senate inquiries found that tape was very probably a compilation of different conversations that had taken place at different times and was quite possibly a third-hand copy.
The committee was as one on the question of the Age tapes. It was impossible to authenticate them, and even if they were a complete and unaltered record of conversation, there was no evidence of misbehaviour against Mr. Justice Murphy.
There were two entirely different things. The tape said one thing and the transcript said something else. It did obviously, and he felt that a lot of it was just concocted. And it was rightfully, his thoughts were right at the time, because what was on the tape and what was on the transcripts were two entirely different things, people's opinions.
The main external threat is the increasing tendency to trial by media in newsworthy cases. Some sections of the media are tending more and more to attempt to orchestrate trials by publication of prejudicial material before and during trials.
At one time they loved him. I mean, I've got cuttings from the Canberra Times in which they eulogised him. But afterwards he was, well, they didn't treat him any differently to anybody else. I mean, if somebody is down, they're like a pack of wolves.
Generally speaking, it seems to me that the Australian media tried to report the affair fairly as it unfolded, but I suppose the two newspapers that took the running were the Melbourne Age and the National Times. Most of the allegations that surfaced did so in one or other of those papers. There's no doubt that people on both those papers thought of themselves as being in a crusade. They were convinced that Murphy was corrupt and they were determined to bring him down. They saw this as a great era of investigative journalism. What I would really say is that what was involved was not investigative journalism, because investigation was precisely what didn't happen. Every new allegation that came up was taken at face value.
The whole thing becomes a focus on the particular character of Lionel Murphy, and a whole lot of other, emphasis gets built up, pushing for a prosecution. A whole lot of his past controversial career gets brought out in the form of things he did as Attorney General and so on, the Sala case, the visit to ASIO and so on, the Morosi and Cairns. Anything that's potentially prejudicial gets lumped in with all this, and so we get a strange sort of demonology developing and being led by this small group of libertarian journalists.
Intelligence material is simply an accumulation of snippets of information. It's frequently gossip, it's almost invariably hearsay, which has come into the hands of security and police organisations. It's not, as the word itself might suggest to people, material which has been verified, and frequently it's material which is unverifiable. increasingly there's a deliberate leaking from within security intelligence collection organisations of the intelligence that they've gathered on individuals and on organisations. And it's simply not the sort of material that would be given any veracity, say, in a court of law. It's not admissible in a court of law. And yet, if it is used within the media, it's of course given a credibility that it simply doesn't deserve.
The press in Australia sets out to denigrate political figures, and that includes conservative political figures, because the whole aim of the barons of the press in this country is to prove that nothing effective can be done by the community, that everything must be left to an uncontrolled, deregulated private sector of people who are in control of the money power and are the least accountable to the public, just as the press is completely unaccountable to the public.
I have been astonished, and I think the public has been astonished, to find that in royal commissions it is now fashionable for witnesses to be allowed to give their speculations on other people's motives, to tell what they heard on the grapevine, and even what their mother-in-law says. The process of demanding a royal commission where there is an allegation of criminality resembles Alice in Wonderland, where the Queen said, first the verdict, then the trial.
I think one of the poignant things about Murphy is that he almost expected, prophesied what happened to him. He talked about the role of self-appointed bodies to do harm, which are in fact subversive to constitutional legal principle. He talked about the dilemma that people needed to be protected against witch hunts. He did, in the Builders Labourers Federation case, point out the total constitutional impropriety of setting up a forum to determine if someone had done any wrong, and thereafter to belt them over the head with it. So I don't think any of that came in as any surprise. I mean, he was involved in battles for years. He put his head up. Those who do expect to have it kicked in. He anticipated it. It was.
Lionel Keith Murphy arrived at Sydney's Castlereagh Street Court this morning to face committal proceedings. Justice Murphy is charged firstly with attempting to influence New South Wales Chief Magistrate Clary Breeze to cause Magistrate Kevin
He
Jones.
was the highest court in our country with one of its own members who was facing criminal charges. It was a desperately sad situation, and I've no doubt that many of the judges of the High Court were torn and riven by, on the one hand, their feelings for Murphy as a person and their natural feelings that in his predicament, friendships should not be severed, because friendships with Lionel Murphy were impossible to avoid.
And the momentum was building up so quickly with all of that, that he really wasn't sure where it was coming from or why there was so much pressure put on him.
Murphy was found guilty of one charge and acquitted on the second. He successfully appealed the conviction and was granted a second trial.
In many ways, Murphy is a significant Labor martyr. He was an extremely successful fighter for the rights of people. He was a man who did not compromise, a man who's given great inspiration to the reformers in this country. And so, both in his achievement and in his inspiration, he is enormously important to those in this country who see that there are things to be done to right the wrongs in the country.
Outside the court, Lionel Murphy spoke for the first time in 18 months, not as an accused, but as an innocent man. Murphy, how
Thank
do you
you.
feel? How do you feel, sir?
I'm glad that it's over. It's been a terrible ordeal for my family and my friends. This has been a political trial, and I hope there are not going to be more political and show trials like this. Everyone in this community is able to be charged by private prosecutors, by others, by scalp hunters, by people who wish to advance their own careers. It can happen to you or to anyone else. We're all open to be charged. We have a wonderful institution in this country, and that's the jury system. And we ought to fight to preserve and extend that system. Thank heavens for the jury system. It's the protector. Yes, it's the protector of everyone in this country, from people who hold high office to every member of the community, and I thank them for their attention. I thank the last jury. They would have found for me, but for the misleading directions which were given to them. Well, the first thing I'm going to do is to take these children, and if I can get in, will be to go to see Crocodile Dundee.
And with that, Australia's third most senior High Court judge took his family to the movies. This afternoon, the director...
The prosecution had ended, but the persecution continued. The media and political campaign to remove Lionel Murphy from the High Court immediately intensified. He had been acquitted in a court of law, and no new allegations had surfaced, but the old ones were rerun. For 4 months, Murphy remained on sick leave from the bench. His health had deteriorated severely. He would not be removed from the High Court, but it looked as though he would never return.
After all, he was found innocent after the trials, and he would have liked to have seen people in government certainly say, well, this is it, it's over now, the man's been found innocent, and yet pressure kept going on ministers and politicians, and they weren't supporting him at all. There could have been an end to it, and yet there was no end in sight over the whole matter at all. Lionel was very disappointed at the fact that no one was willing to put an end to it, and yet he was found innocent.
He had a wonderful death, you know. He wasn't never in hospital. When he died, he was surrounded by people who loved him. But until the very, very last, as long as he could speak, he was still dictating notes to counteract some of the things that were still, as he lay dying, it was still being said. And he was still fighting right until the very last.
Don't give in to the bastards. I think it's the best legacy that he gave. He could have skied the towel a dozen times over that last torturous few years, but he didn't. And I think it's a great thing for people to stand up for their rights. And if you're in the right, don't be steamrolled. And it may be painful to stand up. It may be hurtful to your reputation to have to undergo the scrutiny of inquiry. But if you're right, do it, because even in a system that becomes from time to time tainted, as ours does. So often, right does out, and in Murphy's case, finally it did.